number 13, Sarbat Jahan Fatima versus the Union of India.
Be
For
Lordship. In view of order number 4 and 5, the Union of India was directed to take instruction in view of Shivakant Jha case Lordship, which is squarely covering the petitioner's case decided by Honorable Apex Court Lordship. And I find assistance from my friend. He is having said circular. They relax the said their earlier pre-existing circular in view of Shivakant Jha case Lordship, and for the present Lordship, they are having a modality for the show those employees who taken their treatment in a.
Yes, sir. What is the instruction you have? Union of India.
On 22nd May 2018.
Mike.
On 22nd May 2018, after the order of the Supreme Court, my lord, the modalities has been changed, and
May I furnish,
in
Lordship?
the
I am
health
having
department,
data,
health department has constituted a committee. Those cases which has not been given full payments, they can make a application before the committee, which will be high power committee constituted by the Ministry of Health and Family Welfare.
That was there in 1992 itself.
No, it was in
He has annexed at page number 51.
His case was not, my lord, that he has been paid
May I furnish
as
latest
per
circular,
the
Lordship?
CGS rule, and the CGS rate has been given to the petitioner. Now the petitioner asked that entire payment which she has made during the treatment in a non-registered CGS medical hospital, that has to be paid. There was an order of the Supreme Court in the year 2018, and after that order,
No, whether Union of India or concerned department have taken a decision that it was an emergency case or not.
As per your own circular, whether the matter was referred to the health department that it was an emergency case.
My lord
can prior permission was impossible for the lady to take prior permission.
he has to apply to that very health committee, my lord, health
Sir,
department.
Please come to page 51. Please come to page 51. The government decision, page 51. Annexure 10. Just read it, the undersigned.
Page 52. Learned counsel.
The undersigned is directed to. Please read it.
It is of 1992, my lord.
The undersigned is directed
All right.
to say,
Is there any other? This has been replaced by any other order?
The understanding.
as many of the departments are rejecting the claim without forwarding them to the health ministry for relaxation. Whether this has been deleted.
Who has to give the medical reimbursement? Which respondent?
My lord, that was sanctioned by the department, my lord.
Sir, it is an emergency case. Head of the department, has he taken a decision? It is not an emergency case.
In the emergency, he was hospitalized. Rupees 2 lakhs has been sanctioned by the department immediately.
The facts are not disputed that he collapsed in the office, was rushed to the emergency ward by your head himself. Everything is, now you say that permissible limit is so and so.
Yes.
The lady says that now my husband has gone. The amount that has been, the expenses are.
Sir, in emergency cases, whatever the expenses met by the concerned employee, you are required to reimbursement. Petitioner, you don't know who is the disbursing authority, medical reimbursement.
Now the matter has to be referred to the Ministry of.
No, why we should refer, sir? You take a decision and place it on record.
Yes, you take a decision.
You can't drag the matter like this in respect of medical reimbursement, pension, selection matter.
He collapsed in the office and died in the hospital. This is the
That is the
story.
reason we are asking you who is the authority. We will give direction. Let him come and apprise this court what action he has taken.
The office memorandum is 20th February 2009, my lord.
Mr. Counsel,
My lord.
you are not able to assist this court.
I'm
Show me the decision taken by the competent authority that it is not a case of emergency. Therefore, the petitioner is entitled to only what is that MH?
the,
What rate?
the payment
CGHS rate.
rate, my lord.
Show me the decision taken by the authority.
The decision taken by the CGS authority, my lord. Yes.
That it is not an emergency case. Where is the recording? Recording of reasons.
The decision was taken on 7th July 2014, Annexure 8, page 45.
Page 45.
Yes. Sanction of the competent authority is hereby conveyed for the disbursement of the medical claim not exceeding rupees 30,000 per
Sir, where is the recording of reasons that it is not an emergency case? The petitioners, the deceased employee should have availed the medical facility in the CGHS hospital itself. Therefore, the LRs of the deceased employee are entitled to only CGHS rate. Have you understood?
Yes, sir.
Where is the reasons?
The reason is not there, my lord. The reason is not there.
Huh?
The reason is not there, my lord.
Therefore, ask him to file an affidavit.
Obliging.
Who is the authority?
वो नहीं ना होगा. The Rajesh Ranjan, my lord, I will ask him to file an affidavit, my lord. 3 weeks time may be granted, my lord.
Yes, taken. Question for consideration in the present petition is whether petitioner, legal heir of the deceased, employee dash Nasim Ahmad, ex senior engineering assistant, Doordarshan Kendra, Patna, is entitled to medical reimbursement as claimed by legal heir of the deceased dash petitioner or not. Full stop. The deceased employee was had taken treatment in a private hospital. Accordingly, medical reimbursement was claimed with reference to the payment made to the private hospital. However, the respondents have taken a decision that petitioner is not entitled to deceased petitioner is not entitled to actual payments made towards medical expenses read with the treatment obtained by deceased Nasim Ahmad and petitioner is entitled to medical reimbursement at the rate of CGHS scheme or order. First, perusal of the records, it is evident that the Office of the Director General, Doordarshan, New Delhi, have not appreciated the reason for taking treatment by the deceased employee in a private hospital. First off, it was an emergency case according to the learned counsel for the petitioner, which has come on record. Therefore, whatever the actual payments made to the private hospital is required to be reimbursed, for which the competent authority is required to take a decision. Was it an emergency situation which warranted the deceased employee to take treatment in a private hospital or not? Such a finding is not forthcoming in the documents. Therefore, Director General Doordarshan New Delhi or competent authority is hereby directed to take a decision whether deceased employee was compelled to take treatment in a private hospital on account of emergency or not. Such a decision shall be taken within a period of 4 weeks and place it on record. If the matter relates to medical reimbursement and it is pending consideration for the last 12 years, therefore it is made clear that no further time would be granted to the respondents.
No, Lordship.
8 years.
My lord, one thing addition, my lord, with the permission, my lord, let him refer the matter to the medical
How many times?
Take a decision.
because the health department's committee has been constituted pursuant to the
Sir, you
Supreme
do
Court.
whatever you want. First you have to take a decision whether the matter is required to be referred to the committee or not.
Yes.
Oblige.
Where is that decision?
At least you take a decision whether
Yes.
it is a case fit to be sent to the health department.
In
or
every
not.
case you need not send to the committee. On your own you can take a decision whether it was an emergency case or not.
Oblige.
Facts you cannot dispute. He collapsed in the Doordarshan case and was rushed to the hospital, and he died.
Thereafter,
No thereafter. Facts are not disputed.
to an extent he recovered and thereafter he deteriorated.
Please have some sympathy.
As and when he was admitted to the hospital, was it a serious and emergency or not?
It was
That is
serious.
required to be taken by the authority. That too, if I am correct, the competent authority is medical authorities, who is a doctor who is specialized in that particular subject.
Oblige.
And therefore,
You also remind your authority.
oblige.
A layman cannot take a decision whether it was an emergency or not. Depending upon the record, medical records, the doctor who is specialized in that particular subject, he can declare whether it was an emergency case or not.
Lordship. More should there is no any CGS approved hospital for neuro problem in Patna, Lordship, till date, Lordship.
This private hospital was
Neuro hospital, Lordship.
panel.
Neuro hospital, Lordship.
No,
It-
sir.
Lordship.
It was already enlisted in the CGHS scheme.
No. There is no any hospital who facilitate neuro service, Lordship, in Patna, Lordship. That is admitted fact, Lordship.